The right to environment refers to the recognition that individuals have a right to live in a healthy and sustainable and ecological balanced environment. This concept has gained significant traction in both national and international legal frameworks, driven by the increasing awareness of the environmental degradation and its impact on human health and well-being. National perspective. First is constitutional provision. Many countries have incorporated the right to a healthy environment into their national constitutions. Examples include India. The Indian Constitution does not explicitly mention the right to a healthy environment, but the Supreme Court has interpreted Article 21, that is right to life, to include the right to a healthy environment. Additionally, Article 48A directs the state to protect and improve the environment. Second is South Africa. The South African Constitution explicitly states that everyone has the right to an environment that is not harmful to their health or well-being, and to have the environment protected for the benefit of present and future generations. That is section 24. Now France. The French Constitution includes the Environmental Charter of 2004, which acknowledges the right to live in a balanced environment that respects the health. Second is legislation. Countries have enacted numerous laws aimed at protecting the environment and ensuring sustainable development. For instance, United States, the National Environmental Policy Act, that is NEPA, mandates the federal agencies to assess the environmental effects of their proposed actions prior to making decision. China. The Environmental Protection Law of 2014 emphasizes the importance of ecological protection and sustainable development. Judicial interpretation. Courts in various countries have played a crucial role in interpreting and enforcing environmental rights. For example, India. The Indian judiciary has delivered landmark judgments such as the Vellore Citizens Welfare Forum case, emphasizing the precautionary principle and the polluter pays principles. Philippines. The Supreme Court of the Philippines issued a writ of calication, a legal remedy for individuals or groups whose constitutional right to a balanced and healthy ecology is violated. International perspective. First, United Nations framework. The United Nations has been instrumental in promoting the right to a healthy environment through various declarations, conventions, and special bodies. The Stockholm Declaration. In 1972, the United Nations Conference on the Human Environment in Stockholm recognized the fundamental rights to a healthy environment. Rio Declaration 1992, the Earth Summit in Rio de Janeiro, reaffirmed the right to a healthy and productive life in harmony with the nature. Human Rights Council. In 2021, the UN Human Rights Council passed a resolution recognizing access to a healthy environment as a human right. International agreements. Several international treaties address environmental protection. Paris Agreement in 2015, an international treaty within the UN framework conventions on climate change, UNFCCC, focused on limiting global warming. Convention on Biological Diversity (CBD) aims to conserve biological diversity, promote sustainable use of its component, and ensure fair and equitable sharing of benefits arising from genetic resources. IRS Convention, that is in 1998, the Conventions on Access to Information, Public Participation in Decision Making and Access to Justice in Environmental Matters emphasizes procedural environmental rights. Third is regional initiatives. Regional organizations have developed frameworks to protect environmental rights. European Union. The European Union has a comprehensive set of environmental laws and policies. The Charter of Fundamental Rights of the European Union includes the right to environmental protection. African Charter on Human and People's Rights recognizes the right to a generally satisfactory environmental favorable to a development. That is Article 24. Fourth is international case. We will discuss the international case law. International courts and tribunals have contributed to the development of environmental rights jurisprudence. International Court of Justice, that is ICJ. Cases like the Gabikovo-Nagimaros project highlighted in the interplay between the environmental protection and state obligations. Inter-American Court of Human Rights has issued advisory opinions affirming the right to a healthy environment as integral to human rights. Now we will discuss about the challenges and future directions. First is implementation and enforcement. Ensuring compliance with the national and international environmental laws remains a significant challenge. Effective enforcement mechanisms are essential for realizing environmental rights. Second is balancing development and conservation. Striking a balance between economic development and environmental conservation requires robust policies and sustainable practices. Now, third is climate change. Addressing climate change is critical as it poses a severe threat to the right to a healthy environment. International cooperation and commitments to reducing greenhouse gas emission are vital. Fourth is public participation and awareness. Enhancing public participation in environmental decisions making and raising awareness about the environmental rights can empower communities to advocate for a healthier environment. In conclusion, the right to a healthy environment is increasingly recognized as fundamental to human well-being. Both national and international frameworks continue to evolve, striving to protect the rights and ensure a sustainable future for all. Thank you so much.